Hello, and welcome to the ALCTS webinar on Managing and Implementing License Agreements, Part 2. This is the third webinar in our six-part series on licensing electronic resources to serve the library's mission, and the second in our two-part sub-series on managing and implementing license agreements. I'm Erin Elsie, a member of the ALCTS Continuing Education Committee, and I will be your host for today's webinar. Our presenter today is Jennifer Baisley. Jennifer has a Bachelor's of Music and Master's of Music degrees in viola performance from the Eastman School of Music and an MLIS from Dominican University. She has worked in technical services at the DePaul University Library, the Field Museum, and the Cincinnati Art Museum Library. She's worked for the Miami University Libraries in Oxford, Ohio since November 2009 and is currently an Associate Librarian, Coordinator of Collection Access and Acquisitions. Her research interests include the role of libraries in scholarly communication, improving technical services workflows, and analyzing e-resource usage data. Jennifer brings much expertise to today's topic, and we are fortunate to have her with us. A few logistics for today's presentation. All attendees are muted to prevent background noise, and we do not have interactive chat capabilities. You may, however, comment on today's presentation using Twitter. The hashtag is ALCTSCE. We do not monitor the Twitter feed, so if you have questions for Jennifer, please type them into the question box on your screen. We will have time for Q&A after the presentation. This webinar is being recorded, and you'll receive an email with links to the recording and presentation slides shortly after the presentation concludes. And now, here we'll turn it over to Jennifer. There will be a slight delay as we change presenters.
All right, this is Jennifer. Before I begin, I just wanted to say thanks to the ALCTS committee members and the webinar hosts who have made this process incredibly easy and smooth, and also to George Stachokis, who was the person who organized this whole webinar series and who brought together a lot of great licensing topics and presenters. So I've been coordinating e-resources and serials at Miami since 2009, and you'll notice that I always add the Ohio after the Miami University Libraries because we frequently get confused with the University of Miami in Florida. Often the first drafts of our licenses come along with University of Miami in the opening clause, so that's something that we're always correcting. Like the other presenters in this series, I am also not a lawyer. So the things that I talk about today are just my own experiences and advice and shouldn't be construed as any kind of actual legal advice. I'm going to build today on some of the things that Monica discussed in last week's webinar, including licensing from both an acquisitions and collections perspective. And I'll also delve a little deeper into some of the challenges of coordinating e-resources across so many stakeholders, and of translating our licenses across all of these different ecosystems that we work in. Along the way, I'm also going to talk about some of the tools that I've used and hopefully provide some interesting examples of some of my own successes and failures in managing licenses. And of course, I wanted to mention that there are now a lot of next generation library systems out there that may solve a lot of the issues that I'm going to address today. Unfortunately, we're not able to migrate to one of those new systems. So some of the solutions that I discussed today may not necessarily be as relevant to you if you already have one of those new next-gen systems like ALMA. So first, I just want to speak a little bit to the environment that I'm working in because that has a pretty big impact on the way that we manage licenses. Miami is a public university in rural Ohio near Cincinnati that is primarily residential and undergraduate. We have a full-time enrollment of about 24,500 across 5 campus locations. And like many of you, we manage a huge number of e-resources. Some of those come through consortia, while others are managed locally. And of course, we work with probably more than 100 vendors across all of those resources. Our materials budget is about $4.1 million, and it's been flat for the last 10 years. About 12% of that budget goes towards print materials, and the remaining amount goes towards electronic resources. We use the innovative Sierra ILS, and we also use EBSCO's e-resource management software and their discovery layer. Our current library staff includes 42 paraprofessionals, and 44 librarians across our 3 largest campuses. And within our tech services team, I do most of the e-resource coordination. We also belong to multiple consortia, including OhioLink, OhioNet, and the Center for Research Libraries. Our current library and university administration are really conservative, and the way that our library administration has delegated licensing authority changed pretty significantly in 2013. We got a new dean in 2013, and before that, the previous dean was really comfortable signing all of our license agreements. I negotiated the standard amendments that were required by the university, but she signed everything. They were never reviewed or signed by purchasing or general counsel here. With the start of our new dean, though, in 2013, the license review and signing authority moved to our procurement office. So that was a pretty drastic change for us. And our procurement office at the university has also changed a lot over the last year. They've had a complete turnover in staff and processes. So our license agreements now go through a pretty complex process of approvals by accessibility, IT, procurement, and sometimes general counsel. And last but definitely not least, Miami University is working under an accessibility decree. We were sued by a blind student in 2014. That lawsuit was joined by the U.S. Department of Justice. And while we settled the case with the student in 2016, the Justice Department filed a consent decree that does many things, but one of those is that it requires us to make a lot of changes to our procurement processes and procedures that ensures accessibility. And while this has obviously greatly improved accessibility, it has also made licensing much more time-consuming for us. So as both Lori and Monica mentioned in their previous webinar sessions here, licensing has gone from a somewhat simple process used to acquire an e-resource to a tool that we can use to get the most value out of a resource. And because of that, licensing is requiring an increasing number of skill sets on our side, and it's also, of course, about bridging the gaps in the license chain. It's about coordinating and communicating with what I think of in my head as this really big herd of cats that's spread across the university environment. The licensing process touches every one of the constituents that is on this slide for us. And these stakeholders are really important to me. I depend heavily on their expertise to manage and comply with licenses, but of course, that dependency and that interaction brings with it some challenges. The first one of those challenges are the tools that we use, in that we tend to use completely disparate tools across all these departments to manage our parts of the license process. Most of these tools don't talk to each other or they don't interoperate, and each of these stakeholders may just use one system for their part of the process. So what I've discovered is that it really benefits me if I am able to access and understand and even to use tools that multiple stakeholders offer. A second challenge that we've come across is standardization. So I've worked closely with procurement staff to standardize as much of our process as I can, but as you know, there's never going to be a one-size-fits-all workflow across everything. There's just too many variables for that that are beyond our control. A third challenge is licensing terminology and what I call library jargon. So while some license terminology is pretty standard, that doesn't mean that every stakeholder understands every clause, especially those that get kind of jargony. So there have been a lot of instances where I've had to explain some of the library jargon to procurement or general counsel in order to help them make a decision on whether something is acceptable or not. And the final and biggest challenge is that I don't have any authority over these stakeholders, which means that really my best tools in these processes lie in the creation of positive relationships with good communication channels. I found that a large part of this coordination process is in managing stakeholder expectations, especially in a time when everyone wants immediate access and resolution to everything. And I do this in a couple of ways, by educating my colleagues, by creating awareness of our processes and policies, and by sort of translating needed terms to relevant stakeholders, hopefully in language that they can understand. The licensing process, of course, directly affects the acquisitions process of an e-resource. So acquiring an e-resource is significantly different from acquiring a print resource. With print, much of the work required to make it available to users happens on the back end of the process after the order is made. A staff receives the item, catalogs it, processes it, pays its invoice, and shelves it. With e-resources, we've seen more of the heavy lifting of the licensing process at the front end of the workflow. While most e-resources can be made available to a patron in just a few minutes by a vendor, the negotiation and licensing process that happens at the front end of the workflow now requires a larger time investment. So what this means is that we spend a lot of time communicating information about things like timelines and deadlines to library staff, especially those involved in acquisitions and collections. Many of our staff, whether they're new or those who have been here a while, really have only a vague concept of how much time it really takes to set up a license for a new resource. It used to be that they would place a request for a new resource just a few weeks before a semester started, and then they'd be expected to be ready at the beginning of classes. And right now in our environment with some of our accessibility challenges and processes, this just isn't realistic. And I've worked a lot with our collections staff to help them understand what the process looks like and especially how unpredictable it can be. There are 3 specific timeline concepts that I try to make everyone aware of. The first one is the difference between the fiscal and the calendar year. At Miami, we have an accounts payable practice that we call split accounting. It's called other things at other places, but that's what they call it here. And this means that subscriptions that are dated with a fiscal year range on them are paid in full in the current fiscal year budget, but that subscriptions that might be dated with a calendar year range are actually split over the 2 fiscal years that they occur in. So while we always pay the vendor in full with a single check, the budget against which that amount is paid in our books might span 2 fiscal years. And the amount of that split is calculated based on the time of year that we're paying the invoice, which means that it's not always split evenly into 2 equal amounts. So what this means is that e-resource acquisitions affect our budget differently depending on what time of the year we order them. And this can require some additional license amendments in regard to payment and deadlines. The second thing that I try to remind people of are renewal workflows. We're a state school, and the state of Ohio does not allow us to accept automatic renewals in a license. So this means that all of our renewals are essentially manual, with the majority of those happening obviously on the fiscal or calendar year timeline. Because this process is manual, it requires more time on our part, and that's not always something that people remember from year to year. And the last concept that we talk about a lot here are multi-year licenses. Often a multi-year license provides us with better prices or less inflation on an acquisition. However, it also ties up our flat budget, and that reduces our flexibility in being able to cancel something during that annual renewal season in order to add a new resource. And this is something that I regularly have to remind our procurement office about because they constantly ask me why we can't do more multi-year licenses. That makes their workflow easier, but again, it reduces our flexibility. Another way that licensing has impacted our acquisitions is in the negotiation of big deals. And in Ohio, a lot of our big deals tend to come at the consortial level. So this gives us great buying power, but it really limits our ability to negotiate specific license terms, especially things like accessibility. And of course, consortial purchases also tie up a portion of our e-resource budget. The money that goes towards those purchases can't easily be reallocated from year to year to purchase something that might be needed. Finally, we've seen acquisitions and licensing change a lot with the addition of new purchase models. So as technology has evolved, we've seen a larger variety of those models like PDA. And these models have added a lot of complexity to our decisions and our licensing processes. Those making these acquisitions decisions now have to know and understand the benefits and challenges of these models in order to make the best choices. And those benefits and challenges are often spelled out in our license agreements. In the next couple of slides, I'm going to discuss in more depth how we've addressed some of these challenges in our own acquisitions. It's still really interesting to me that in this really complex licensing landscape, our library at Miami is still using the ILS as its acquisition starting point. The base of our process is still a bibliographic and an order record, no matter who we buy it from or what format the resource is in. And as I said earlier, we practice a sort of split accounting here. In Sierra, we only track our real-time invoices and payments to vendors in the current fiscal year. We do not track the split payments across fiscal years in the Sierra ILS because it can't really accommodate 2 accounting systems in the same fiscal year. So this means that by necessity, there's a lot of communication that goes on during the year between our library's budget assistant and myself and our acquisitions librarian. Our budget assistant is the person who works with university accounts to make sure that the invoices are paid and also to maintain a spreadsheet that tracks those split payments across the year. Knowing the state of those split payments throughout the year then in turn allows us to make better and more realistic acquisitions decisions, and also ensures that I can negotiate any special licensing terms that might be related to timing of payment or type of payment required. One of the things that varies a lot from vendor to vendor is how they interpret and enforce the payment deadlines that you find in licenses. Fees and payment terms are often included in those agreements, but the clauses really vary in specificity. The license agreement for this particular resource stipulated only that invoices be paid on, quote, a timely basis, unquote. And that is a license term that I did not amend with anything more specific when I reviewed this license. In a license, the timely basis is not defined by an actual amount of time, and it also states that the result of non-payment on a timely basis is a suspended account. So as you can see on the right, our account was suspended, and not just once, but multiple times. And of course, in each case, the account was suspended before I received any notification, and so that caused a lot of confusion. The invoice that caused this particular suspension was due on January 28th. We had received it and paid it a month before, on December 29th of the previous year. We ended up working with our university accounts payable very closely, and we were able to determine that, using bank records, that the vendor had cashed the check we issued on January 17th, which certainly fell well within the timely basis. However, on the vendor side, something happened, and they somehow misallocated that payment in their own system, which automatically triggered the account suspension because it looked like we were violating our license. And this exact same scenario with the same vendor happened multiple times over about a 1.5 year period, and I got increasingly frustrated. I pushed back on this vendor each time it happened. To me, it felt unfair for us to be repeatedly penalized for something that was their mistake. So after pushing back a number of times, at this point, it's been about 6 months since we've seen this error. So I'm hoping that whatever issue was happening has been resolved. In the meantime, though, I've realized that I need to revisit this license with 2 amendments in mind. And the first is to try and define the timely basis with a concrete amount of time. And the second is to insist on the clause that requires the vendor to contact us before this account suspension happens. So many of us purchase e-resources through big deals or through consortia to increase our buying power. Unfortunately, when we acquire e-resources this way, sometimes these large big deal licenses can cause confusion and bottlenecks in our acquisitions. I was contacted by a subject librarian about this particular ebook title. Her faculty member wanted to assign this ebook as a text for a class, and she was going to purchase the title with her subject materials funds because she didn't find the title in our catalog, which basically means that it's not part of our license. However, when she went to the vendor's online site, she saw that we had full access to all of the content in this ebook, every chapter. And she then assumed it was part of our ebook consortial package, and she happily notified the faculty member, thrilled that she wouldn't have to spend her acquisitions money. But when she asked me about why it wasn't in the catalog, I investigated further with consortial staff and discovered that this title wasn't in fact part of our consortial license. The vendor had mistakenly turned the access on at their site, but it wasn't legitimate access. So at that point, our librarian made the decision to use her funds to buy the ebook locally for the class in question. The amount of time required to establish all of this and communicate it among myself and the subject librarian and acquisitions librarian, consortial staff member, the faculty member, this all drastically slowed down an acquisitions process that is normally really quick for an ebook with a pretty good turnaround of maybe just a day or 2. So in this instance, like in so many others, communication and good relationships among librarian colleagues and faculty members were what eventually allowed us to solve this problem. The increase in types of purchase models available for e-resources has also changed acquisitions, and this is most especially evident in the ebook process. So when you select a print material for purchase, you have relatively few options, the choice between maybe paperback or hardback. But with ebooks, you have a lot more choices to make, and that's dictated in part by type of license agreement that you have in place with an individual publisher, and in part on how a librarian expects that an ebook will be used. We order our ebooks for local use through Gobi, And Gobi, in turn, manages our licenses for about 20 individual ebook publishers and aggregators. The number of choices that you see on this slide when you go to order an ebook are staggering, and in a lot of cases, our new subject librarians who might be requesting an ebook for purchase for the first time, they see these choices and they're just totally overwhelmed. What does concurrent access mean? What does nonlinear mean? How do I choose between 1 or 3 user? Is DRM free on EBSCO the same or different or worse than DRM free on JSTOR? So a typical scenario is that a faculty member asks a librarian to purchase an ebook for use as a course text. A single user access model isn't going to work in that scenario. So we as e-resource and acquisitions librarians know which providers we're licensed with, what we've negotiated with each vendor, and we help determine and communicate which of these access models will best suit the needs of the patron. And like almost all of these other licensing challenges, this one again just requires us to coordinate across a lot of stakeholders and be really proactive in our communication. Over the years, it's been really interesting to see how license terms and agreements have influenced collection development strategies. While we try to maintain a flexible collection development policy that serves everyone's needs, when we're reviewing a new resource, there are now certain license terms that for us are deal breakers that influence our collection development, things that we simply can't support or agree to in this environment. And we've stepped back from several new purchases over the years because a vendor or publisher couldn't meet those needs. When we do sign a license that has terms that affect our patrons, one of the biggest challenges that we face is communicating those license terms to librarians and patrons who are using the materials. And we found that some of the greatest challenges on both of these fronts occur with accessibility, authentication, consortial licensing, format-specific considerations, and user restrictions. So over the next couple of slides, I want to speak in more depth about some specific license terms that have required really extensive work on the collection development and communication fronts. As I mentioned earlier, here at Miami, we are working under a federal decree for accessibility. And this means that before purchasing or subscribing to any new resource, that resource is put through a rigorous accessibility review process by our university's accessibility department. So before I submit a new resource to accessibility for that review, I have to obtain from the vendor a VPAT, which is a voluntary product accessibility template for the product. I request that the clause you see on this screen be added to the existing license agreement. And I procure trial access to the database in order for accessibility staff to access that database and test it. Each of these steps has its own challenges. Many smaller vendors don't have a VPAT or don't even know what that is. We try to work with those vendors to create a VPAT and educate them. Some of our larger vendors, who will remain nameless, question the language of the accessibility clause, and I then go back and forth with them about what I can and can't accept. Because of this process, I sat down with our accessibility specialists, and together we created a workflow that really spells out what I can and can't accept in this language. That workflow has helped me a lot in negotiating with vendors, but it also allows me to know when I need to hand off the negotiation to someone with more accessibility expertise than myself, and that's been a really valuable thing to know. Finally, the issue of trial access. I've had a couple of different vendors question trial access. Instead of giving me access, they've tried to set up demonstrations of their project with staff. And demos are just not sufficient for accessibility testing. And so we've had some significant challenges with just a handful of vendors who couldn't seem to understand that. So these requirements for us have effectively added a new layer to our collection development strategies. And what that means is that a new resource can be vetoed if it doesn't meet these accessibility requirements, and if the vendor is unwilling to work with us on trying to adapt to those accessibility requirements. And the best example that I have of that actually happened last year. We have a new fashion program here that's a co-major between art and business. And the faculty teaching those courses needed access to a fashion database that's pretty unique in the market. The vendor of the database was clearly used to working with business and corporate clients as opposed to educational ones. And so we struggled over negotiating all of our standard kinds of license clauses. But because this program was new to us and the database was unique, the university was willing to overlook some of the shortfalls in the license. Unfortunately, accessibility was one of the biggest sticking points. This vendor just would not budge on adding any accessibility language to this agreement, which for us is normally a deal breaker. In this instance, we were able to get an exception from our accessibility office with the assurance from the vendor that they would work with us over the year to try and address some of these issues in their product. Well, the year passed and renewal time came around for this resource, and the vendor just flaked out on their promise to work with us. They continued to refuse to amend their license, and my accessibility and procurement staff told me that they simply could not sign this license agreement for renewal. So by this time, I had an anxious librarian, an art librarian, and an anxious faculty member who was supposed to be using this in a couple of weeks. And I felt like I was trapped between all three of these constituents, trying to explain to each one in turn what the issues were from every perspective. It was at this point that I finally decided to just have a meeting with all of these players in the same room. So someone from procurement, the faculty member, the art librarian. And that meeting was actually one of the best that I had last year. With everyone at the same table, we were really able to make everyone understand the unique nature of this database. We were able to explain our concerns about accessibility issues to the faculty member. And in the end, everyone was much more sympathetic to the situation that we were in. And we were able to agree on licensing a different fashion resource that was not exactly the same, but similar enough to be used in the course. Another aspect of licensing that's really impacted collection development for us is authentication. So generally, we only purchase or subscribe to things that can offer IP-based authentication and that allow remote access by easy proxy. We try to avoid any sort of username and password setup unless we're in a really desperate situation, because that's just really hard to support with a large FTE. One of the best examples of authentication's impact on our collections just happened this summer. A law database that we had subscribed to for many, many years, and a fairly expensive one, came up for renewal, and the vendor told me that they were moving all of their customers from an old platform onto a newer one. And I thought that sounded great because it would finally give me access to usage statistics. But the vendor came back to me with the new license agreement, and that actually stipulated that for a slightly higher cost than last year, the database on the new platform would not be available to our whole IP address range, but would be limited to 2 single static IP addresses that had to physically reside at workstations within the library. And I have to say that I literally laughed out loud when I read that. I went back to this vendor and I asked if this was negotiable, if one of these IPs could at least be that of my proxy server. And her response is what you see on this slide. In 2018, I had a vendor, a really large vendor, tell me that IP authentication across my network was impossible. And I thought about how I would explain this to my faculty and students, how I would explain to them that to use this resource, they had to come to the library and use one of 2 dedicated workstations. In 1994, I could have sold this model. In 2018, I could not sell this model. I explained to my librarians and the faculty that we just could not justify this kind of expense for this kind of authentication model. And more importantly, that we don't want to support and encourage vendors to continue with a model like this. So in the end, we canceled our subscription and we reallocated the funds to something else. As I said in the previous slide, we obviously only try to purchase things that allow for IP authentication and easy proxy, but there are always some vendors or resources that won't work with that model. And so we have a handful of things where we are contractually obligated to authenticate in different ways. And these exceptions cause our users and librarians quite a lot of frustration, especially when that alternate authentication method isn't straightforward. So we currently subscribe to the New York Times with a site license, and that was negotiated through the Center for Research Libraries. That consortial agreement that was negotiated by CRL doesn't allow for off-campus access by easy proxy. But this resource had a huge demand on our campus, and so we made an exception to our usual policy and subscribed. The authentication process for the New York Times is completed through an initial registration and then a semi-annual renewal process that must happen from a Miami University IP address physically located on campus. Outside of registration and renewal, of course, users can then access this resource with their account from anywhere in the world, but they have to be on campus for registration and renewal. This renewal of authentication has been the biggest barrier to use, and we see constant questions by chat and email about this process. The confusion on the process also extended to library staff, and so faculty looking for help troubleshooting were often left even more confused after talking with staff. So we've tried to address this issue in a couple of ways. First, by educating our staff and librarians about how this resource works so that anyone who comes to a staff member gets a consistent response from us. Second, we've created a public-facing LibGuide and an FAQ entry in our LibAnswers FAQ that provides information to patrons about this. And we've tried to avoid using jargon as much as we can, avoid using terms like authentication, and to provide as many means of getting in touch with us as possible. We still haven't found an ideal solution to this problem, but having multiple modes of communication has definitely helped. One of the best ways that we have of increasing our buying power is to leverage consortial purchasing. However, this means that we have less control over license negotiation. In the state of Ohio, of course, big deals tend to be purchased at the consortial level. So this provides us with access to a huge number of resources, but it does limit our ability to negotiate specific terms. And while the consortia generally agree across the board on standard license terms, one area where our requirements have differed from the consortia is in regard to accessibility. Because we're working under this federal decree, we're required to negotiate more specific accessibility terms with our vendors. And our consortia do not currently negotiate these same clauses as part of their standard processes. For many of these resources, in that case, we have or will create what we call, and what everybody calls, equally effective access plans with each of these vendors, and also just work individually with the vendors and publishers to document their accessibility standards. The other challenge with consortial licensing is with management and subsequent communication of those consortially negotiated license terms. So OhioLink and CRL both provide license terms to their members through password-protected online systems, and we rely heavily on these kinds of online tools when looking for licensing information. Unfortunately, we've not had the time or staff to put this license info into our local ERM, and these systems are not interoperable with each other. So while any member of the consortia within our university can certainly get accounts to these and look up license information, I've become the sort of translator and gatekeeper for everybody because I visit these sites so frequently and know how to get to the licensing information that's needed. As I talked about earlier during the acquisitions discussion, ebook purchasing is really complex. It's hard to serve the needs of your patrons through collection development without understanding the specifics of each ebook vendor's license agreement. And one of the ways that we found to communicate internally on the complexities of some of these e-resources is by creating a technical services LibGuide. And there we offer information that's specific to us about the acquisition and collection of our e-resources, as well as a lot of different kinds of license restrictions organized by e-resource format. One of the most useful ones that we've created has been the page on ebook platforms. So we buy access to ebooks on a sort of bewildering variety of platforms that have a really wide variety of use restrictions relating to things like whether they can be downloaded, what format they live in, what software is required, whether materials can be copied and printed. So we created the chart on the left in order to compare the sort of basic user restrictions of ebook platforms sort of side by side. And this chart has become really popular internally with subject librarians who are troubleshooting ebooks with patrons as a sort of starting point. We've also created more in-depth pages on the same guide for each of the sort of major platforms that we buy from that spell out in much more detail the relevant license terms, and hopefully in language that staff understand. That includes information about whether things are leased or owned, what kind of user access model, accessibility information, how we catalog them, and whether usage reports are available. And so this allows for a type of self-service access to license terms in a format that is much more user-friendly than our e-resource management software. One of the most challenging aspects of managing these licenses lies in communicating the end user restrictions that appear in licenses to the actual end user. So in a system where patrons can get to these resources from so many places like catalogs and discovery portals and Google and LibGuides, how do we let them know what they can and can't do with these things? What we've noticed is that part of the answer to this question is that a patron will ask us for this information at their point of need. And so we've tried to give them as many opportunities to do this as possible through things like proactive chat boxes on the library site and on LibGuides and in EBSCO Discovery. But we also try to place the relevant information where it will be likely to be noticed by users, or so we hope. For example, for any resource that appears in our catalog that has a user restriction, we add a note to that link text that tells you what the restriction is, so one simultaneous user, for example. And this is, of course, most common with ebooks, as you can see here in the upper left. Additionally, we put those same user restriction notes on the records in our A to Z list, which is what you see on the bottom left. And finally, we put user restriction notes in our database's A to Z list, which you see on the right. We're also using that A to Z list to indicate some basic permitted uses for these resources, things like course pack use, ILL, electronic linking terms. So this was put into place for both staff and end users, but has been more popular with staff so far. The licensing process that we've talked about can create ecosystems that span all or even small subsets of the stakeholders that we talked about already, along with the workflows and the tools that they're using to manage their processes. These ecosystems can be administrative or technological in nature, or sometimes both at the same time. Often we see multiple kinds of tools being used across a single ecosystem. Sometimes those tools create redundancies. Frequently they are not interoperable, and we have found little product integration across them. This makes our challenge as e-resource librarians to understand and fit into these ecosystems, and in some cases to be the sort of bridge that brings everything and everyone together on the other side. In recent years, I would say I've spent the majority of my time in an ecosystem that includes the libraries, procurement, accessibility, and IT services. And so I've learned the benefits and limitations of the different tools used by each of those players, and also how to best communicate amongst all the staff in those units. In the next few slides, I want to talk about a couple of those tools and address a couple of scenarios in which the ecosystem has been put to work in managing licensing challenges. As I said earlier in the presentation, our licenses go through a rigorous review process by both university, accessibility, and procurement staff. And the university's preferred way of tracking all of this is a procurement system called Byway, which allows for centralized management of vendor goods and products for the entire university. Since we purchase a lot of resources with licenses, procurement asked us to learn how to place requisitions into this system when a license needs to be reviewed. This tool is not interoperable with any other tool that we use, and it does duplicate some of what we record in our ERM, but it's preferred by the university administration, and so we're sort of locked into using it. We have a really conservative procurement office, which means that licenses go through the 7 approvals that you see on the top of this slide before they get to the purchasing officer for signature. This can create a significant bottleneck, especially for a license that is somewhat complex. One good aspect of this system is that it does allow me to see exactly where the bottleneck lies. And now whether or not I can do anything about the problem is a separate story, but at least I can see where the license stopped. In addition to tracking where a license is in the process, it can also track the history associated with the requisition, as well as any comments or files that have been uploaded to the form. One great feature of the system is that it does allow us to notify one another with emails when we've entered something new. This means that I can communicate with everyone from accessibility to procurement to general counsel, all from one requisition in this dashboard. What isn't so great about the system is that it doesn't really offer any kind of version control for documents. So as you go through the amendment and negotiation process, it can be confusing to view all of the document versions in this system and to know which one is the final completed version. And this system also theoretically does have a vendor participation component in that vendors can be certified in order to use this portal along with us. However, few vendors have made it through that process, and so the feature has not really been heavily used. Of course, no presentation on licensing would be complete without at least one slide on ERMs. We've been using EBSCO's ERM for a number of years, and we don't utilize it, I would say, as fully as we could, in part because it's labor intensive to get materials not ordered through EBSCO into this system. So some of what goes into our ERM does duplicate what resides in our Byway system and even in our ILS, but we do still maintain all of these tools. Really the biggest barrier with this ERM is to library staff trying to use it. It can be really confusing to find what you're looking for in here, and this is primarily true of ILL staff who might be looking for terms on a specific journal title. Because we get so many journals through multiple aggregators, The search results for a single title like science can be really confusing. So while we haven't identified a significantly better way to help internal staff with these restrictions, we are experimenting with using our LibGuides database's A to Z list to enter some of these basic restrictions. And this has been, I think, more helpful for internal staff use for ILL and for staff making course packs for faculty. I mentioned earlier that the library has collaborated closely with university accessibility staff. One of the challenges that we ran into as collaborators was how to track our VPATs. We work with a large number of vendors, many of whom have multiple versions of these documents. The library's ERM can't accommodate the storage of VPAT documents, and the university's Byway software can store documents but provides no organization or tracking of versions. So after discussion, we ended up using a simple shared Google Drive folder organized by vendor name. And there are definitely more sophisticated ways of tracking this information, but given that VPATs come in PDF or Word format, this method of organization and sharing has been the best fit for us. Everyone already understands how to use Google Drive, so there's little training required as far as keeping this up to date. And of course, at some point, it would be great to use our ERM to track all of this information as well, but we just haven't had the staff time in order to enter that information. A case of excessive downloading of a licensed e-resource is one of the best ways that we've had to exemplify how the workflows and collaboration between a vendor, the libraries, and IT works in this sort of chain of license coordination. So we use Easy Proxy to offer remote access to our users, and sometimes compromised university credentials allow for systematic downloading through our proxy, and they result in a vendor blocking our access, sometimes without telling us. When these breaches do occur, I work with our IT at the university level to determine which account has been compromised, and then we can reset that account. However, sometimes what vendors identify as excessive use is actually nothing of the sort. This license clause appears in the American Chemical Society standard license, and like lots of vendors, it states that they monitor the use of the materials, they have the right to block our access if they consider that we've been abusing these materials. So while we have had breaches with a couple of different resources, we've found that the usage thresholds that this particular vendor sets but won't actually quantify for us are really low, and that a lot of legitimate kind of use can trigger them. At the end of the last 3 semesters here, ACS has blocked my account. And the first time it occurred, I worked with ACS and someone in IT to narrow down the problem usage from a broad IP address to a specific lab in our chemistry building. This, in turn, allowed me to identify the faculty member who ran the lab and reach out to communicate with him. As it turned out, the usage that triggered the suspension was actually totally legitimate. Our organic chemistry students in this lab take a very intensive exam at the end of each semester, which is a part of the process for them to become PhD candidates. The faculty member explained to me that these exams deal with a specific subfield or focus, and that subfield is represented by an issue or issues of an ACS journal. So that particular month's organic chemistry exam was on synthesis, and students were asked to download all of the articles from a couple of themed issues of ACS journals. So yes, the students were downloading all the issues from a specific volume, but they were doing it for a legitimate and really important purpose. I explained all of this to the vendor, and I told them that the professor would try and let his students know to, if possible, avoid this kind of downloading, but that given the nature of the exams, this type of use really seems to me to be legitimate. And so I asked them if there was any way they could raise the limit on our account, or if they could put a note in our account stating that this was going to happen at the end of every semester. And they basically told me that they couldn't do that. Their response was just not that helpful. Their system blocks are automatic. They are triggered by a number of downloads per session that is set by their IT security and management teams. Those parameters can change without notice. So unfortunately, they were just unable to accommodate my request for any of these changes, which means that at the end of every semester, we see this same blockage. And so we communicate with the same group of people each time and let them know that this, is not unexpected. My final example for today involves a license violation that really expanded the sort of boundaries of my licensing ecosystem, both in an administrative and technological way. We were contacted out of the blue by the general counsel from a vendor who sent me the notification you see at this slide. She noted that it came to her attention that some images from the resource had been posted by users at my institution on a site called studyblue.com without the consent of the vendor, and that this was a violation of our license agreement. This was the first time I had ever heard of the studyblue.com site. And at the time, it was a standalone student sharing site that allows students to post materials in the form of flashcards that they create with content from specific courses at specific universities. So students self-identify their university and course affiliations and post content, and that can include visual materials like photographs and things like that. StudyBlue is actually now a part of CHEG, which is a for-profit company that provides things like textbooks and tutors and other academic services to students. So when I initially got this email, the first thing that I did was to contact our University Information Security Officer. His position resides in our University IT, and his role includes the duty of being our official DMCA liaison. And DMCA stands for Digital Millennium Copyright Act, which is a US copyright law. And I knew from some previous conversations that he had worked with our general counsel on past issues like this that involved copyright and third-party sites. And after discussing with him, I was able to respond to the vendor to ask if they could provide me with some examples of this violation, as well as the proof that they had that the user violating the copyright was actually one of our students. And while they could point me to these images that they felt had been uploaded in violation of copyright, they couldn't actually provide me with any verified proof that these were Miami students. The infringer in question had posted under the Miami University category, but they were simply using an anonymous username. And so there was no way to know for us whether this user was a legit Miami student. Since we didn't own the copyright to these images, we weren't really in a place to ask this StudyBlue site to divulge their user's registration information. So our information security officer helped me to craft this response to the general counsel from this vendor, basically asking her to submit her report of this violation to the third-party site itself, per the StudyBlue site's own DMCA compliance policy. And that would be the first step in getting the copyrighted content taken down from the site. And then the site, if they could positively identify a Miami student as the source, could send us that information, and then we could address that student. And at this time, I also made our art librarian and faculty, as well as my own supervisors, aware of the issue in the hope that it might help to prevent future infringements. And I learned a lot while working on this particular issue, and I was really glad that I had reached out to our information security officer. His expertise was really valuable in helping me communicate with this vendor in a way that we all understood. So everything that I've discussed today, I think, reinforces the fact that these licensing challenges are going to vary across institutions and individuals. The tools that we choose to use are going to continue to change, as they already have over the last 10 years. But the essence of successfully implementing and managing our licenses isn't going to change. It's always going to require the ability to build bridges across people and what they do, the ability to create collegial relationships internally and externally, to educate and to advocate, and probably most importantly, to communicate. And as I was preparing this webinar presentation, the Horizons 2018 Higher Ed report happened to be coming out. And this year's report identified a challenge that struck me as particularly relevant to all of the issues that we face in managing licenses. Horizon identified this challenge as a difficult challenge, which they define as one which we understand, but for which solutions are elusive. And to me, that describes exactly what we face. And that challenge is adapting organizational designs to the future of work. The idea that institutions are being forced to rethink traditional functional hierarchies and replace them with more team-based flexible structures. And while this type of flexible thinking already exists among ER librarians, I think it'll be interesting to see if this same flexibility will be translated and more formally applied within the structure of our organizations. And then just a few publications that I think are of interest. There are obviously tons of articles about licensing, but I think these are really interesting and worth reading. The second article, called Technical Communicator, is probably the most interesting. It explores the similarities between e-resource librarians and technical communicators, especially in their roles as a sort of bridge or translator between end users and other stakeholders, which I think plays a big role in the licensing process. And I would also highly recommend the book, Reengineering the Library, which is an ALCTS monograph, as it covers a lot of the licensing aspects that we've delved into in this webinar series. So that's the end of my presentation. So if there is time and if there are questions, we have a few minutes to talk about those. And I think there may be an issue with the audio on the part of the presenter. I mean, not the part of the presenter, the host.
Can you hear me now?
Yes.
Okay, sorry about that. So if you have not already, as Jennifer said, you can have time for questions. So go ahead and type your questions into that question box there in your go-to control panel. And we have had a couple that are already come in. The first one was, what is the name of the item that you requested from the vendor for accessibility?
The name, the VPAT, or Voluntary Product Accessibility Template. I think that's what the question is asking.
Yeah, I think so. If not, if whoever submitted that wanted to clarify, we can get back to it.
Yeah.
And the next one, how do you communicate license terms to patrons?
To patrons? Well, that's a good question. Our primary ways so far have been through things like link text in our catalog, through notes that we can put in our A to Z lists, in our LibGuides and LibAnswers. We've started experimenting quite a bit with setting up FAQs through that SpringShare LibAnswers module, which has been actually helpful for after-hours kinds of questions about license terms. So things like authentication and user restrictions, especially in regard to ebooks, which seems to be one of the most problematic of the formats as far as licensing is concerned.
Great, thank you. And then just a question, we had someone who was wondering if you could flip back to the book list, and maybe we'll just have it sit on that slide.
Oh, yeah, sure.
While we go forward with any other questions.
Yeah, I think that's the one.
Great, thank you. And all right, the next one is, if you could choose any way of tracking the status of your licensing process, would you choose another system?
Oh, that's interesting. Yes, I would choose another system, and that system would somehow be able to closely integrate with my email. One of the things that I didn't talk about, but that I think is really interesting, is the fact that even with all of these systems and softwares and technologies, at the end of the day, the thing I use the most often in tracking and negotiating licenses is email, and that is true across all of these stakeholders. And for years, every vendor who asks me what I want, I have said, if there is some way to integrate email directly into this system so that I could track my negotiations and my conversations about all of these things, excessive use and amendments and breaches and platform questions, that would just really, that would be the best tool for me. And so far, I have not found a tool that does that. But that would be some sort of single software that could integrate closely with the emails that we use to solve all of these problems and track all of these things would be my sort of most desired system.
That sounds lovely. It exists. And then we had a response from the person looking for the book list, and they actually meant the required readings slide.
Oh, I'm sorry.
Recommended readings, I'm sorry.
I heard book list, and there it is.
Perfect, thank you. All right, so our next question is, how have you been able to handle publishers and specifically professional associations who do not know what a VPAT is and may even ask you if you can help them write one? Have you canceled essential publications from associations unable to provide a VPAT and whose content hosts cannot provide one?
That's a great question. What we have done for the majority of the vendors who did not have a VPAT or didn't know what one was to work myself and someone from our accessibility office with that vendor. And what we've done is to provide examples of VPATs to them for other sort of similar kinds of products. And our accessibility department has actually created a pretty concise, nice little website that is meant specifically for vendors to tell them the kinds of things that they need to look at to put into the VPAT, and sort of also to talk about the kinds of people within their company that need to be helping with the VPAT. So in some cases, vendors don't understand that they need to work closely with their software developer or with whoever is sort of built the software in order to answer some of those questions. So the answer is that, yeah, we try to work with those vendors to help them create a VPAT. We've only had one instance so far over the last few years where a vendor simply, at the end of the day, just refused to fill out the VPAT. They claimed that they had no staff or time to do so and that it was just too low on their priority list. And that was a resource that was so very niche and used by such a small set of subset of faculty that the university did eventually let us sign the license even without a VPAT. But that is the only one where we've made that exception. As I mentioned earlier, there was a fashion database that we canceled, and that vendor refused to do a VPAT, and we did cancel that subscription.
Great, thank you. And then we do have time for one more question, and it is, will non-US vendors agree to Section 508 accessibility language in the license? And how do you work with international vendors?
That's also a great question. The example that I just mentioned, which was the vendor of the very niche database, is actually an international vendor, a European vendor, and they were the ones who basically would not sign any sort of accessibility language. They wouldn't fill out a VPAT. Generally speaking, we have been able to work with both international and US vendors to create language that they are able to agree to. While they won't necessarily comply with, every last clause that we would like to have them do, we have been able to negotiate with them to get the language that we need. As I said, there have been a few exceptions. And in a few cases, we've also spent sort of a year between renewal cycles working with a vendor to sort of update that language and get them to accept it. But so far, for the most part, we've had pretty good success even with international vendors.
Great, thank you. And so that was our final question. That's all the time we have for questions today. We did have one more attendee who asked to look at a specific slide. However, we do send out the slides to everybody at the end of this. So even though we don't have time to go back to that slide, you will be emailed those slides. So keep an eye out for that. And so I just wanted to thank everyone again for being with us today. You will receive that email soon that has both the link to the slides and the recording and an online evaluation form. So if everyone can take a few minutes to respond to the questions in the form, their comments are very valuable and do help the ALCTS Continuing Education Committee plan future events. You also have the opportunity to now receive a certificate of attendance, and that information will also be included in the email. And thank you again to our presenter, Jennifer Baisley. And thanks also to members of the Continuing Education Committee, Catherine Balick, Iping Chen Gaffey, and to Alana Warren from the ALCTS office. The support that they provide make it possible for us to present these webinars. ALCTS also has other continuing education events coming up. We have 3 more webinars in the Licensing Electronic Resources to Serve the Library's Mission series, as well as additional webinars through the remainder of 2018. The next webinar will be on Wednesday, September 12th, covering negotiation and cost containment strategies for electronic resources. Please see the ALCTS website to register or to find more information on these. ALCTS also offers web courses, which are 4 to 6 weeks long, as well as 2-day email discussions. Our next e-forum will be on September 18th, discussing writing strategies and tools for staying on track from start to finish. Check the website for more information on upcoming courses and discussions. And once again, thank you all for joining us today, and this will conclude our session.